In the middle of July 2021, the Albany, New York Common Council voted 9-2 in support of Local Law F, otherwise known as Good Cause Eviction. Mayor Kathy Sheehan, at an outdoor ceremony, signed Good Cause Eviction into law. She touted it as one of the cornerstones of her administration. A few months later, 5 different parties collectively sued the city of Albany in the Albany County Supreme Court to have good cause eviction overturned. A number of months later, actually June 30th, 2022, the Honorable Justice Christina Reimer rendered her decision and order in regards to the Albany Common Council's passage and law of good cause eviction. The Justice's decision was that good cause eviction in Albany, New York is null and void. Now, her decision is 7 pages long. It has many references to statutes and case law. We are going to summarize her decision in layman's terms for 2 reasons. One, to show you the foundation of her argument, and the second reason we're going to hold off until the end, and it's a surprising reason that will help other landlords across New York State. What the foundation of her argument was is what they call preemptive doctrine in the state of New York. There are 2 aspects of the preemptive doctrine. Now, what that looks at is local government's ability to adopt laws. They are allowed to do that unless it conflicts with the preemptive doctrine. And there are 2 aspects of that. There's the field preemption, and that is where local governments will enact legislation or enact laws, whereby the state has the responsibility, the regulatory responsibility, to have that law in place. So they can't do that. It's up to the state. The other one is conflict preemption. And what that means is that local laws cannot be adopted that are inconsistent with state law. In other words, that conflict preemption states that a local law cannot prohibit what state law explicitly allows. And Local Law F in Albany, New York was and is in direct conflict with conflict preemption. What she basically says, the court finds that Local Law F is barred by conflict preemption. What this did, what good cause eviction did in the city of Albany, is it put forth 10 different provisions, regulations, whereby the landlord had to meet one of those 10 in order to garner the eviction of the tenant. The other aspect was that rent could not be raised more than 5% unless it met various provisions, one of a few. One of those provisions, believe it or not, was could the tenant afford a 5% rent increase. So if the landlord brought forth the tenant to court for eviction because they did not pay the difference of the rent increase and wanted to evict them for non-payment of rent of that rent increase, and the tenant was able to prove to the court that I can't afford that 5%, the landlord's case would be dismissed. Completely disregarding what state law, real property and procedures law, and real property law allows. So upon looking at all of that, she said, you can't do that. You can't restrict what state law allows. There is provisions that allow a landlord to evict the tenant under state law that you are saying that they can't do. Local Law F places an impediment upon landowners' free access to the courts and limits the remedies provided under RPAPL, Real Property and Procedures Law, and Real Property Law. They couldn't do it. Now she goes on further to state that Local Law F alters substantive provisions and procedures of existing state law by imposing limitations and prerequisites to the commencement of an eviction proceeding that are not required under state law. Now, the City of Albany, under their Corporation Council, ruled otherwise. They said that it is not in conflict, not at all. It does not have anything to do with rent control, rent regulation. It has nothing to do with impeding the landlord's ability to evict the tenant. We just have wanted to impose other regulations that they need to have and other stipulations that they would need to follow in order to evict their tenant. It is unbelievable that the Corporation Council of the City of Albany would not look at this and state that it clearly, Local Law Act, Good Cause Eviction, is in direct conflict with state law. Unbelievable that they would do that. She ordered that plaintiff's motion for summary judgment is granted, and the City of Albany Local Law Act is declared to be null and void. Therefore, good cause eviction is no more in the City of Albany, the first municipality in New York State to have good cause eviction. Now, we say the first municipality because there are 4 more that have it. 4 more municipalities: Beacon, Kinston, Newburgh, and Poughkeepsie. Now, the second reason why we have explained this video to all of our followers all across New York State is that we also want to have the local government leaders in those municipalities view this video and know this, that unless you local government leaders in Beacon, Kinston, Newburgh, and Poughkeepsie, if you do not repeal your good cause eviction laws, now we are coming for you. And we are going to see that your local laws regarding good cause eviction are either repealed or the governments in your counties, your Supreme Courts will have it ruled null and void. We implore you to do the right thing and repeal it now. Landlords, we ask that you subscribe to our channel, hit the notification bell, hit the like button, so that you will be made aware of other videos that we are going to produce for you to help landlords, because as you know, our motto is helping landlords become better landlords. Until then, take care.